When two branches of government push back on executive power in the same week, you know the Constitution is still trying to do its job, even if fewer people are paying attention. Let's start with the courts. Just days ago, a federal appeals panel declined to pause a lower court ruling that kept temporary protected status, TPS, in place for over 600,000 Venezuelan immigrants. A district judge had ruled that the Department of Homeland Security likely exceeded its legal authority in trying to end those protections. And now, the Ninth Circuit said that ruling will stand, at least while the case plays out. Even where Congress delegates discretion, courts can stop unlawful terminations when they exceed what the statute permits. This is exactly what the founders intended. Not because they foresaw immigration law, but because they feared concentrated power. In 1803, the Supreme Court said it is emphatically the province and duty of the judicial department to say what the law is. That was Marbury v. Madison, the ruling that gave us judicial review. The idea that even presidents must answer to the law. Now, shift to Congress. This week, 48 U.S. senators, every Democrat plus one Republican, introduced a bill to nullify two recent executive orders that directed federal agencies to cancel union contracts and strip away collective bargaining rights. In the House, a companion effort is just 2 signatures away from forcing a floor vote. This is Article 1, the legislative branch trying to reassert itself. Because these orders didn't just tweak policy, they attempted to dismantle decades of civil service protections with the stroke of a pen. We've been here before, too. In 1883, after years of political patronage and corruption, Congress passed the Pendleton Act, establishing a merit-based civil service. That reform was about keeping federal jobs above partisan power grabs. And this moment feels familiar. So, in the span of 2 days, we've seen the courts enforcing legal limits and Congress trying to reclaim its role over the workforce that runs our democracy. 2 different flashpoints, same deeper tension. When the executive moves fast, who has the power to say no? The founders wanted an energetic executive, yes, but Hamilton warned that energy without accountability could become dangerous. And Madison built a system where ambition would check ambition. And in 2025, we need those checks more than ever. Because when power concentrates too easily, when courts are ignored or Congress is sidelined, the whole system starts to tilt. We need courts that enforce the law. We need legislators who don't surrender their role. And we need citizens who understand that the process, not just the outcome, is where democracy lives. So here's the question. When power overreaches, which guardrail do you trust most? Congress, the courts, or the Constitution itself? And what part of it are you willing to stand up for?